Thank you for joining the NCATS Presents Essential IP Advice for Small Business Commercialization. The webinar will begin momentarily. My name is Monique Laroque, and I wanted to go through a few quick housekeeping items. We would like this webinar to be interactive, and we know that you may have many questions. At the end of the presentation, we will have a Q&A period to respond to your questions. However, you can chat us your questions throughout the entire webinar. To do that, use your chat window on the right or, depending on your screen, on the bottom, and we'll review the questions at the end of the session. We are offering closed caption today, and you can get technical support as well. At the conclusion of the webinar, we hope that you will provide us input, and we will be chatting out the link to do so as well. Please take a few moments to give us your feedback. With that said, I want to welcome you again to the webinar, Essential IP Advice for Small Business Commercialization, featuring our partner, USPTO, on patent application and the examination process. We invite you to join the conversation on Twitter, as well as to use our hashtag NCATSSBIR. With that, I want to introduce our featured speakers. Today we have Lily Portilla, she's the Director of Strategic Alliances from the Office of Strategic Alliances at NCATS NIH. We will also hear from Dr. Ram Shukla. He is a Supervisory Patent Examiner at the USPTO. With that, I want to thank Dr. Shukla and the USPTO for joining us in the presentation today. During our presentation, you will be learning a little bit more about NCATS, SBIR, and STTR programs, and other small business resources to help foster innovation and technology development. And we'll also talk through how to protect your IP for small business owners and the role the USPTO plays and other resources for the small business community that you should know about. With that, I'll turn it over to my colleague, Lily Portilla from NCATS.
Thanks, Monique, and I appreciate everyone tuning in and listening to this webinar, and want to thank Ram Shukla from USPTO for participating and sharing information to our community. Very quickly, I wanted to give a very brief overview of the NCATS SBIR STTR program. The NIH SBIR STTR program has several ways that individuals can apply to the program. The primary way that academic entrepreneurs as well as small businesses can participate is via the omnibus solicitation that has standard deadlines of April 5th, which is coming up, and September 5th and January 6th of every year. Those dates are standard deadlines. We also on the NIH website and on the NCATS website have targeted grant solicitations where we have listed or participating in solicitations that are of research interest to the organization, and due dates there may vary as well too. Once a year, usually in the summertime, we release our contract solicitation, and applications for that solicitation for small businesses to participate are typically due in the October-November timeframe. Next slide, please. So the NIH SBIR STTR program is one of the largest sources of early-stage financing for small businesses in the life science arena. This past year, the SBIR STTR budget for the NIH was over $1 billion, and that's money that is set aside specifically for this program. We are not able to reprogram it for other initiatives. This is a program that has great bipartisan support in Congress, and as I said, it's a significant amount of money that is set aside for small businesses here at the NIH. Next slide. The The benefits of the program are many, but we see it as a stable and predictable source of funding. As you can see that the SBIR STTR budget is tied to the NIH overall budget, and it's not a loan, and funds do not have to be repaid. It's non-dilutive. All the IP rights that are developed under these grants and contracts are owned and retained by the small business. If you are able to get one of our SBIR STTR awards, you're also eligible to participate in other technical assistance programs that the NIH has to help small businesses, and training opportunities as well. And I think one of the other main benefits of the program is that our projects undergo a rigorous scientific peer review process, and many of our awardees are able to leverage that peer review in order to attract more funding and strategic partnerships for their companies. Next slide. So here we outline what the funding eligibility requirements are for the SBIR and STTR. These requirements are set by the Small Business Administration, not the NIH. All federal agencies that participate in SBIR, STTR follow these eligibility guidelines. A small business is considered one that has 500 or fewer employees, and that for an SBIR, the PI's primary employment has to be with a small business, and more than 50% of the company can be owned by individuals or independently operated, or more than 50% can be owned and controlled by other business concerns. And you can also, if your small business has ownership by multiple VC or operating companies or hedge funds or private equity firms, you may be eligible also to participate in applying to the program. STTR is a little bit different. STTR requires that there be a research organization as a collaborator under the grant, and here the PI can either be an employee of the research institution or an employee of the small business. If you are using intellectual property that belongs to the university and you need it to in order for the company to have freedom to operate with the intellectual property, we do require that there be some kind of IP agreement that at the time of award we would have to make sure is in place that demonstrates that you have the ability to use that intellectual property that may be owned by the research institution. Next slide. The SBIR STTR program is a three-phase program, not to be confused with clinical phases. Phase one is typically feasibility studies, and those are budget guidelines for NIH's around $225K, although it's always important to look at the specific funding announcement to see what the budget guidelines are there, and to talk to the respective institute that you're applying to see if they have what their budget guidelines are also. Some topics that NCATS has identified, we do allow our applicants to go past these budget caps that NIH has, and you can go up to $325,000 for a phase one, and up to $2 million for a phase two grant, which is typically more, more R&D that is going on. The project periods for a phase one can last anywhere between 6 months to a year. For a phase two, they can be anywhere between 2 and 3 years. And sometimes we also participate in what's called the fast track, where you can apply for the phase one and the phase two grant at the same time. And a direct to phase two is a program that we have here at the NIH that if you have enough data that you have feasibility data that you would have gotten under a phase one and you have that data already, you can skip that phase one and go directly to a phase two. Some institutes participate in the phase 2B competing renewal program. NCATS does. Our caveat is that we must have funded your phase two grant. and all institutes have different rules around this, so it's always good to check with individual institutes that you're applying to. Phase 3 is what we categorize as the commercialization phase, and if you're pretty much graduating from the program, keep in mind that NIH is generally not the customer of whatever you're developing, and at stage 3, phase 3, we're hoping that the company is trying to figure out other strategic partnerships and other ways to leverage funding that they receive through the grant through other private sources. Next slide. So I won't go individually through these, but here in the slide deck are some of the current funding opportunities that that are open. As I said, the omnibus solicitation is the way that most of the grants come into the NIH, and it's list all the research interest of all the participating 24 institutes here at the NIH, as well as our sister agencies that participate, the CDC and FDA. And there's some other specialized and specific funding announcements here too that you're also eligible based on the topic that you may be interested in applying to as well. Next slide. So in closing, if you are interested in learning more about what what NCATS funds, we encourage you to go to the NCATS Small Business web page to learn about our funding opportunities and research priorities under the program. If you can also check out our FAQs and funding solicitations that are open. And if you have any questions, you can contact us via our email box that is listed here. And we are happy to talk to you about any ideas you have about applying to the program. And if you're not a good fit for NCATS, we're going to send you to the right institute and refer you to one of our colleagues in one of the other institutes here at NIH. And I believe that completes my brief overview of the NCATS program. And with that, I would like to hand over the presentation to Ram Shukla from the USPTO, and as I said, we're very excited about this opportunity to for Ram to talk about some resources out there that the USPTO has for small businesses, and be looking in the future for other helpful webinars that NCATS will be organizing in this arena. So with that, I will hand it over to Ram. Thank you.
Thank you, Lily, for the introduction and for the opportunity. So I'm a supervisory patent examiner at the United States Patent and Trademark Office. And let's get started because I have a lot of material to cover. So next slide, please. Okay, so the presentation has 3 parts. Part 1, we will do just an overview of intellectual property. In the second part, we are going to talk about patent process, patent application, and how examination is done. And then finally, we'll talk about some of the tools and resources that USPTO has got for inventors on its website and also in person. So we are already on the next slide. So USPTO has got headquarters in Alexandria, and we also have got these regional offices in different parts of the country. Now, America Invents Act that was signed in 2011 by President Obama, he, when this AIA, we call, was signed in, one of the requirements for the office was to open regional offices. The reason being that headquarters being in Alexandria and inventors and businesses being all over the country, if someone needed information or help, they had to travel to Alexandria. So that's why these regional offices were opened. Now, these regional offices are like a mini, size office of the headquarters, which they will have basically all the same facilities as the headquarters have. Next slide, please. So the headquarters are in Old Town Alexandria, and basically it's the main campus which houses the administrative offices, and then it also has got a public search facility where inventors can come and do search of patent databases, and they can use the same tools as the examiners use. Now, these tools are also available in all the regional offices, so they also have smaller search facilities. And then there are also examiner interview rooms where you can come and interview examiners. Sometimes if you have an examiner working in the different part of the country, you can come to either the headquarters or one of our regional offices, and then you can connect with the examiner through video, and you're able to discuss your case with the examiner. We also have hearing room for the board, what we call PTAB. And then we also got some public meeting spaces where you can come and use this space for IP related meetings. So that those are some of the facilities available to inventors and everyone. Excuse me. Next slide, please. Okay, so just to give you an overview of the office, we have about 12,000 plus employees. Of those, we have got about, excuse me, we have about 8,200 patent examiners. Now, these numbers are from 2018, so the numbers may have changed a little bit. We also have 549 trademark attorneys, and then we have 383 judges, and then we have got the trademark board where we have 73 judges there. Now, in fiscal year 2018, we had 643,000 plus applications filed, and then we had 338,000 patents issued. And on trademark side, we had 468,000 plus, almost 469,000 applications filed, and then we had 273,000 plus certificates of registration. So these numbers, they change every year. Patent examiner numbers are kind of same. Just to give you a flavor of that, we have almost 60% or 55 to 60%. Other numbers may be plus minus. Examiners who work from home, we call patent Hortling program. They telework from anywhere in the country, and similar programs are available in trademarks as well. Next slide, please. So let's talk about intellectual property. And again, this would be a brief one. Our main focus is going to be on patents. So there are three types of IP we can say we have. One, patent. Then the other one is copyright. And then we have trademark. Now, trade secret is another IP. I mean, there's a difference between trade secret and all others, right? And so talking about the patents and IP in general, I mean, technically, as the name says, that the property of intellect, the property that is because of your intellect, that's what is intellectual property. So what can be patented? So we have three types of patent. One is utility patent. What that means is, as the name indicates, utility means it has use. Okay. Second one is design patent, which is a patent for the ornamental, just the design. It has nothing to do with the function, design of the article. And then you can also get a plant patent. Now, plant patent could be, in fact, two types. You could even get a utility patent for plant too. But the plant patent, when we say it is for asexually produced plants, okay? Now, you can have recombinant, plants, transgenic plants, and all those will be in the utility plant area. Again, use is the reason why. The utility means use, okay? Now, some of the examples, as you will see, I mean, I don't need to go through all these, that, for utility patent, your iPhone, iPod, and fertilizers and medicines, all these are utility patents. They will be covered by utility patents. Sometimes you have transgenic mice, which could be used for screening compounds, or screening drugs. So they will be, again, for utility patent. Now, duration of protection, so you have 20 years from the date of filing, okay? That's what the protection is about, okay? So now what happens usually when you file the patent application, that sometime, it will take time to process it, but your total number of years is 20 years from the date you filed your application. Design patent has gone 15 years, and then plant patent again has 20 years from filing date. Copyright is another IP, and copyright is for books, photos, art, images, films, videos. And then, again, you have all these different examples like music, artwork, and video. And then, so what is the protection? The life of the author plus 70 years, are some works 95 years from publication and others 120 years from creation. Now, for copyright, you really don't have to go and register or do anything. The moment you put on paper something you write, you have copyright. Now, the idea of going and registering, getting a copyright certificate is that way, if somebody has copied, then you can go and sue that person and really stop that person from copying your stuff. So you need the registration for that. Now we have got trademarks. Now you get trademarks for words, symbols, logos, designs, or slogans that identify and distinguish product or service. The big thing about trademark is that that's how people know product. That's how people, for example, a big one is, let's say, Google, or for coffee, you know the name, where you will go. If you go and buy coffee and somebody is not selling the coffee you want or what you thought it was, then there's that's why the trademark is there, to get that protection. Same way, if you see a bottle with Coca-Cola logo on that, you will expect that that's what you get, not anything else. Now, trade secret is different. Now, when I say different, means I think questions sometimes comes that, well, should I patent my invention, or if it's a formula, for example, or should I get a trade secret? The idea is that when if you patent it, okay, you have to disclose what is in that formula. Because the idea is that when you get a patent, others will see that and they can, use it. So you have to disclose how to make that and how to use it. If you want to have a trade secret, you cannot, keep that secret. If you want to have trade secret, you have to keep secret. If you can keep secret, then you have trade secret. Now, there are protections where if you can show that somebody stole your trade secret, and there is a process, then you can go and sue that person, right? But if you cannot keep it secret, you have to decide what you want to do, whether you want to get a patent or a trade secret. Keep it as a trade secret. Again, as an example, Coca-Cola formula is something which people have tried. Now, one big thing about trade secrets is that if your product is out in the market, people will try to reverse engineer it, and there is no protection against it. Next slide, please. So what is the role of IP in the U.S. economy? Some of the, here, some numbers are here from 2016. As you can see, IP contributes hugely to U.S. economy. And I'm not going to go through all these numbers. I mean, you will have a copy of the slides and, look at it. But they really impact the U.S. economy. And world economy too. Now we have basically a global economy. So, and that question will come again, when you have an IP in US, but because of everything is global nowadays, you put something on the internet, people will have it. What protection do you have, and how do you protect it? Okay, next slide, please. So briefly talking about what is really role of the patent system. So the first one is it protect inventions. Well, how does it protect? Because it gives the inventor an exclusive right for a certain period of time. So that's what the protection is. Now, remember that you get exclusive right. You have to go and enforce your patent, right? It's not automatic. Now, it encourages inventions. How does it encourage invention? Well, when people see your patent, they will, they may go and add to it, modify it, and do more research to make it better or something new. Promote commercialization and application of invention. So that's the another, because when you have a patent, then you can go and, raise money and then, change it to a product. And then finally, accelerate the commercialization of invention to the whole society. So the part being that people will have this new product you created and they will benefit from it. And then, more commercialization in the sense they will buy and more people will make money. So that is part of the entire, the patent system, how it helps. So next slide, please. Now, talking about the office a little bit, just about the organization. So USPTO is an agency under the Department of Commerce, and an Undersecretary of Commerce is our boss, or head of the USPTO. And then under the Undersecretary, we also have a Deputy Undersecretary. The Undersecretary is also called Director of USPTO. Now, the Director of USPTO advises the Secretary of Commerce on domestic and international IP issues. So now, under the Undersecretary's office, we have got two commissioners, one commissioner for patents and the other commissioner for trademarks. Now, the patents operation is under Commissioner for Patents. And then the patents, we are divided into what we call technology centers. And there are technology centers that deal with different technology. For example, I am from Technology Center 1600, which is biotechnology and organic chemistry. And the other technology centers, which are listed here, I mean, they all examine different different types of technologies. I mean, you have to think in the sense that if an application is filed, at the office, patent application is filed at USPTO, somebody has to examine that. So they, one of these technology centers, it will be assigned to, and it is based on, and we have got a classification system. When I say classification system, it's not the classification in terms of classified information, but rather as you see in a library where books are listed and by subject and all that. So same thing, we have a system. And using that, the application will be assigned to a technology center, which will have expertise to examine that subject matter. Now, for biotechnology technology center, where we have got what we call working groups, which are, these are like departments, you could say. So for example, we have got a work group which deals with nucleic acids. We have got a work group which deals with proteins. Then we have got work group which deals with antibodies and treatments. And then we have for pharmaceuticals. And then within each work group, then we have got group of examiners, smaller groups of, anywhere from 10 to 18 or 20 examiners who would specialize in a particular technology within that work group. So for example, in nucleic acids, we have my own art unit. I am supervisor of one such group we call art unit, where we examine applications on antisense, siRNA, microRNA, and then methods of treatment and related technology. So we use, so same way there are other art units, which will be, one is for just, oligonucleotides probes, PCR. So this is how the office is organized, and this is how we are able to distribute the applications to where they should be examined. Next slide, please. So what is a patent? And as I mentioned before, so it's really a patent. It provides you, it's a property right, right? So it's a right to exclude others from making, using, selling, offering for sale, or importing claimed invention, okay? There is a term, so that exclusion is for a certain term. And as I mentioned before, it's 20 years from the date of filing, and it's territorial. So what that means, and I think that's most important question, or most important point here is that if you get a patent in US, it does not give you protection in any other country. So there is no worldwide patent, okay? So you have to, and again, it becomes part of the strategy of your business, that if you want protection in multiple countries, then you have to apply for a patent in those countries. Now think about it, that if you were to, you have market for your product, whatever it is, in different countries, and you put it on the internet, you have only protection in US, you have a US patent. people will see that product and they can go in that country and they can copy, make it. You really cannot do anything. I mean, there are certain ways you could try to, but you don't have much of protection. Same way, if you were to produce that product in another country, then they, the company or the factory, whichever is producing it, they could copy and sell, fake items, copy of your product. Again, you don't have, protection just with US patent. You have to get patent from that country. So there is a mechanism, there is a platform which is called Patent Cooperation Treaty. And we have, I think as of 2018, 152 countries who have signed that treaty. And under that, you can file an international application. You can choose the countries where you are going to prosecute or apply for patent. And they all can be managed under one platform. The filing date will be same. The documents could be moved between offices. There are different programs, initiatives which can be used. So there is such a platform which will help you to file in multiple countries. Now, the application you file in PCT or under PCT, it does give you search report, which can be used by multiple offices. It also does some preliminary report on examination. These are some optional things you can get. And again, different countries can share that information. And then, your application can be prosecuted in those countries. Now, you have to remember that different countries may have different patent laws, right? Rules. So you cannot assume that if you got a patent in US, you can get a patent in another country, because, if the laws are not same, they will, or each country is going to prosecute your application based on their own laws. So, but then still the resources are there, available for the other countries. So that is available to you. Next slide, please. So as I mentioned before, so we have three types of patents: a utility patent, where you have a new and useful process; machine, article of manufacture, or composition matter, or any new and useful improvement thereof. So this is basically the list of things which you can patent. And then, the design patent is the other one: any new, original, and ornamental design. Protects the way an object appears, so it's an appearance. And then the plant patent, where it invents or discovers and asexually produces any distinct and new variety of plant. So rest of the discussion is going to be on utility patent. Okay, next slide, please. So how do we get a patent? Now, as you see here, you see the first block as new idea. Just word of caution here that, idea, you cannot patent an idea. Remember, it's a utility patent, how to make and use, right? So you have to, your idea has to be converted into a utility product, and one of the what we had listed before, what you have seen before. And so once you have that, then you can file a provisional application, which is optional. You don't have to file. And you have 1 year, and within that 1 year, you have to file a non-provisional application, which will get examined, and you will, if it gets approved, then you get a patent on that. Okay. Next slide, please. So just going back further and talking a little more about these two types of applications, provisional and non-provisional. So provisional application, it has 1 year time period, means, the day you file it, it will expire after 1 year. Okay. You use it for getting priority, right? File for filing date priority. And the idea being that you have 1 year. Within that 1 year time period, you can decide what do you want to do. Do you want to file a non-provisional patent, and when I say do you want to, means you will decide based on your business, what you want to do further. If you get a patent, do you want to get a product developed, and so on. So all those things you have a year to decide on, figure out. Okay, you don't have to put any claims in there. It will not be examined. Nobody will look at it unless you file a non-provisional, and then the examiner may come back and look at it for what you have put in that provisional. And then it's not, and then there's no provisional application for design or patent. So provisionals are not allowed there. Okay. Non-provisional application, on the other hand, is the one which gives you the patent. Okay. It is what will be examined, and you need to have claims filed in there. Okay. Now, again, I said, when should you file provisional application or should you not? I think one thing you have to think is that if you are thinking about talking to people and sharing with them your invention, okay, while you can have NDA, it would be a good idea to file your provisional, because with provisional, from the date you file, you are covered. Means when you file your non-provisional, your filing date will start from the date of the provisional application. So when it is examined, you are covered for that time period. Okay. Next slide, please. So how much does it cost and how much time does it take? Okay. So as of 2019, April 2019, an average pendency for a patent application was 24 months, and it's similar, maybe a little bit less nowadays. It could be longer depending upon what there are a lot of factors. When you file an application, is it complete? Is it complete in all the sense before it goes to the examiner? When the examiner looks at it, if he finds something else is missing. And one good example for biotech people, I will say, is sequence. A lot of times people file an application and they put some sequences in the listing, not all. So when examiner sees it and it will be sent back to you, you have to put all the sequences. Sometimes there are no sequences in there. So all those things add to the time of processing of your application and getting the patent. Now, so there are fees, right? You have to pay, and there is a general filing fee, and then there is also a search fee and an examination fee. But there could be some additional fees, and the link here, if you go to the link, it will provide different kinds of fees you have to pay. Now, what about small businesses? So for the small businesses, there are initiatives, and in fact, there is reduced fee, and for what we call a small entity and micro entity. Both of these have certain requirements you have to meet to be categorized as one, and so fees will be reduced for these two. And then after an application is examined and is determined that it's patentable, then it can get you have to pay an issue fee there too. Okay, and then after that you have to pay maintenance fee at different time periods, which are listed here: 3.5 years, 7.5 years, and 11.5 years after patent issues. Now, one question you can ask, again, well, are patents affordable? Now, these are the fees we are talking about, is what you have to pay to the office. But on top of that, when you have attorney fees, which are, which could be big, and then with that also you get, preparation of the application, size, complexity, and different things, they all add to the cost. Now on top of that, when you are working with the examiners and there are extensions and all these things, they could also add to the fee. So it's a relative thing. It's hard to say, well, how much it will be, but there are different types of fees, and some of these are here. So next slide, please. So just give you an idea of what is an application. What do you have in a patent application? What do you have to provide? So the parts of an application are a title, abstract, drawings if you need, to show your invention, background of the invention, brief summary of the invention, and a brief description of the drawings, and detailed description, and then claims. Now, claims are the real deal because that's what are examined, and that's what you get a patent for. And in court, if you have to defend, or, that's what you will be. So invention is the claims. Other parts of the patent application, they really support the claims. Next slide, please. So, well, what should a claim be? And when we say scope of the claim, what does it cover? You cannot be too general. If your invention, like here, it shows in the middle you have invention. If you go too broad, it may not be patentable, and it would be too general. And if you become too specific, then it may not be as valuable to you as a patent owner. So when you are working and when we are examining, that's why we have to determine what is the proper scope of the claim. And I just use a simple example here that if you have a single family house, then where are your boundaries? Basically, how do you determine that? You cannot claim the entire street. You cannot claim the entire, development where your house is. So you have to, where are your property rights? Basically, that's what the claim scope, in simple form is. Okay, and during examination, that's what the examiner is going to work on, examine and determine. So next slide, please. So what is the process? In making it very simple is that when you file an application, you are, whoever your application is assigned, or owner, if you want to call it, then so it goes to, it comes to our office, and it's called a pre-exam division, where they will look for all the formalities. And then after that, they are going to decide, basically, based on classification, well, where should it go? And so, you saw the list of technology centers. It will be sent to one of the art units, and then it will be assigned to an examiner. The examiner is going to, examine and go through your application, and they will have back and forth with you. And for each application, basically, when you file, you have what we call 2 bites of an apple, which means that examiner is going to send you an office action or a correspondence. You respond, and then examiner will take a look at it, how you responded, and then make a final determination whether you get a patent or not. And that really closes prosecution. So that's why it's a 2 bites. Okay. And so if you get a notice of allowance, it gets allowed, then you get a patent. If, it was rejected, did not get allowed, then it gets abandoned. So that's what, in very simple form, is the patent examination. Next slide, please. So just to give you another quick review of the process, that when the examiner gives you the first, so does the first examination gives you an opportunity to look at it, you have now you can amend the claims and send it to examiner, to take a look at it for second examination, and then decide, examiner will decide whether they meet the requirement or not and decide to allow or, not allow. And then your options are that you can let the application go, or you can go to the next process, appeal to the board called PTAB, and Patents Trial and Appeal Board, and they can decide whether, okay, examiner made an error or not. So then, and there you can get a notice of allowance, or they could affirm the examiner. Okay, next slide, please. So what does the examiner do really? I mean, the idea is, or the basis of US patent system is that unless the office can show that you don't have a patent, or your claims invention is not patentable because they do not meet requirements of the US law, you have a patent. So that is the initial burden of the office of the examiner to show that you do not have. And why? That's what you will get in the correspondence. Okay. So next slide, please. So that's what an examiner does. He or she will read and understand the invention, and then determine what are the meets and bounds, scope of the claims, will search what has been already done, and then determine based on this the patentability of the invention. Okay. Next slide, please. So there are several statutes. That's what we check your invention for, and the first one is 101. And so let's go to next slide, please. Okay, so what do you get, or what can you apply a patent for? A process, machine, article of manufacture, composition of matter, an improvement of any of the above. Those are the 5 things, right? You can apply for a patent. They need to be a new, non-obvious, and useful. Those are all really part of the statutes. So for a biotech, what is a process? Well, if you synthesize a new compound, new drug, that is a process of making a compound. You treat the disease, that's a method of treating, that's a process. Machines could be your PCR or your, PCR machine or sequencer. Article of manufacture could be the same. You create a new vector for transfecting a cell. That would be composition of matter, a protein, a peptide, a compound, and then you are improving any of the other. So these are some of the examples where are things you can apply for a patent in biotech. Yes, my time is running short, right? Okay, next slide, please. So what are the requirements here? Okay, you get only one patent, okay, for each invention. So you cannot have, and that's where there are what we call double patenting rejection. You can see that because if there is overlap between your 2 patent applications, has to be useful. That's utility. And then, and these are the list we told you: process, machine, manufacture, composition of matter. And then whoever invents or discovers. Okay, so you can only a patent may only be obtained by the person who engages in the act of inventing. Somebody else cannot get a patent on somebody else's behalf. Okay, next slide, please. Okay, so in addition to the 101 we talked about, it also needs to be novel, And non-obvious, novel means nobody has done it. So exactly same thing, nobody has done it. Non-obvious means if all the information is available related to that technology or invention, it would be obvious for another person who works in the same field to do it. And then we need that it should be adequately described and enabled. Enabled means, again, it's a how to make and use is required, means a person who reads your application, your patent, should be able to make and use it. And that it is described in clear and definite terms, okay? So those are the requirements for an application. Next slide, please. So this is going more into the statute. So let's move on to next slide, please, because we have some other things we want to share. This is the other part of the statute when we talk about indefiniteness and distinctly claiming the subject matter. Next slide, please. So when we talk about non-obvious, something is not obvious. Again, the idea being that would it have been obvious, for a person having ordinary skill in the art to use the information available and make that invention. So these are all the determinations which an examiner has to make, to say whether a claim is patentable or not. Next slide, please. Okay, this is an example, of a claim that has been issued, a method of treating okay, so tongue twister here. In a patient having such condition comprising administering to the patient therapeutically effective amount of compound or pharmaceutically acceptable salt thereof. So think about it. Here you have the disease and you have the compound. And can you make it broader? Can you make it, less, breadth for the claim? Okay, next slide, please. So what resources do we have? Lot of resources, in fact, and this is a good collection of the web pages. You can learn about the patent process, how to search. There's a IP awareness assessment tool. Inventor and entrepreneur resources are there where you can reach out, ask specific questions. There's a process assistance, means that, if you are preparing your own application, not using an attorney, there is a resource for that. So all these resources are available and much more on our website. Please do visit and take a look at them. Next slide, please. This is the most important tool, I say, examiners use. This is we also say Bible, MPEP. This is what you use for examining. It has all the laws and rules and regulations. Next slide, please. So this is an example. I've said, just a snapshot of the our patent process overview. Next slide, please. So these are some initiatives about applications at different stages of application you can use if you want accelerated examination. And so again, we don't have time to go through that, but to have a look at these. Next slide, please. This is a dashboard. We provide information that if you want to know, what is dependency and a lot of other statistical information you can get on our website. Next slide, please. You can have, you can interview with examiners, and this is one of the ways. So next slide, please. Okay, next slide, please. We touched on this, but you have to go and try some of these. This is a tool to learn about IP. And next slide. if you have a problem, you're not working, working with the examiner, there are issues, you can reach to Ombudsman Program, and they are there to help you. Okay, and next. Okay, that was the last slide. That means, well, I'm sorry I had to rush the last few slides, but we'll be glad to answer any questions, and thank you for your attention.
Thank you very much, Dr. Shukla. We have received many questions, and we'll go through as many as we can. I'm going to give the first one to Lily, and then we'll move over to the USPTO specific questions. Lily, is there a difference between the NCAT SBIR program as well as the NIH SBIR and STTR programs?
The NIA, is that what you said?
NIH broadly.
No, so the NIH, being a federal government agency, has an SBIR program. Each of the institutes also have them, and the institutes, the various institutes have specific research missions and initiatives that may track directly with the types of topics that they are looking for. As I mentioned in the omnibus solicitation, that's the best way to figure out what's going on across the NIH. There's a document, a hot link in that solicitation that allows you to see what all the different institutes are looking for, as well as the FDA and CDC. You could do a keyword search in the PDF and see basically which institutes would be interested in the type of proposal that you would like to submit to the NIH. So we are part of the NIH, and we have our own budget line that we manage here, as do the other 24 participating institutes.
Thank you, Lily. I also wanted to note that I sent out a link via chat to everyone with the link to NCAT specific research priorities for the SBIR and STTR program, as well as the funding opportunities page. The next question is for Dr. Shukla. Can we patent artificial intelligence algorithms specifically designed for certain clinical applications?
Okay, well, great question. And so you cannot patent algorithm itself, but you can patent a process for doing something using the algorithm. That would be my short answer. Now, we have had a lot of, so recently, a lot of case laws about 101 subject matter eligibility, and that being is AI eligible for patenting? And I think that's where I will say that you can use it for a method of doing something using the algorithm. Now, natural laws or abstract ideas you cannot patent, so you have to be careful in there.
Great. So we have two other specific types of what is patentable questions.
Mm-hmm.
One is, can we patent the antibody sequence of an antibody produced by a mouse due to the mouse being invoked by immunogenic stimulus, or does this fall under the naturally occurring?
Okay. Well, I mean, again, the one answer we give most of the time is it depends. It's a, hypothetical question, hard to say. But if you used a recombinant peptide to produce an antibody, and the recombinant peptide is unique, and then antibody would be unique. So you might be able to patent that. I mean, I hope that answered the question. So it all depends. That if the antibody you produce in the mouse is naturally occurring, means it is produced against a known peptide, known protein, then most probably you cannot patent it. But if you use a unique peptide, recombinant peptide, which is not present in nature, to produce the antibody, you might be able to.
Great, thank you. During the presentation, you mentioned non-obvious, and some folks would like to get more details on that. If a utility patent was abandoned and a new application is filed in which a similar process is targeted, but with different molecules, can a patent be granted?
So let me understand the question that application was abandoned and a new application was filed using the same information. Can that be
Similar process, yes.
similar process? Well, so since 2000, all the patent applications filed at the office are published. Okay, they are called pre-grant publication. So that means it would be available as a prior art. And which also means that if you use that prior art or known application, even though it's abandoned, but it's published, then it will be used in obviousness rejection. Is your application, excuse me, your application or your invention obvious over what was present in that published application or abandoned application? So when we talk about obviousness, you have to think what is, if all the information is available, what you have in your application out there, you know, papers are there in publication, in patents. So would a person working in the same field be able to use all that information and then make your invention? So really that's what is, you know, considered as being obvious or non-obvious. Hope that helps.
Thank you. The next few questions relate to timeline and some more specifics. So I'll begin. If you file a provisional patent, but someone else files a provisional patent with a similar idea before you, however, you have substantive data backing your claim and they do not, which one is awarded?
Okay. So the, you know, first thing is that who filed it first, because that's the test really, is that first to file is the one who gets the patent. Second, when you file a provisional application, how much did you describe, or other party, how much did they describe? Remember the statutes I talked about, you know, we'll be looking at, well, can one make and use based on the information you have given? Now, you are not required to reduce to practice, as we say. It could be prophetic, right? But at the same time, it should be enabled, means using the technology available at the time, the invention can be made and used. Now, let's take the example of treating cancer, a particular type of cancer, and treating that particular type of cancer is unpredictable because of various reasons. When I say unpredictable, means you use known drugs and you cannot treat them. You have to use specific drug, to treat it. Now you come back and you put an application where you describe, okay, I have this drug and it can treat it, and you put all the experiments in there, but you haven't done anything. Well, based on what is already known, can that cancer be treated? In that case, examiner will ask, well, it cannot be done because this is what art says. You have to now show the data that it can be done. So going back to your question, it depends on what the invention is. You may, just describe, or somebody may describe and may be able to get a patent, but or not get a patent, based on or depending on what the invention is. Excuse me. Sorry.
Thank you.
Yep.
If a patent application was abandoned, is there an option to revive the application if a few years have passed?
Okay, it's a great question. Now, again, what is few years, right? So if you let an application abandon, let it go abandon, you should try to revive it as soon as possible. That's what I will say. Yes, it can be revived.
Thank you. So someone is picking on your analogy of 2 bites of the apple and one They want to go through some more clarifying questions related to that.
Mhm.
So what about when the initial exam has questions, you respond, they're describing that as the first bite,
Mhm.
and then they decide they need more information, so you reply back a second time. Then they respond saying that the initial issues are resolved, but now there's a new issue. You
Mhm.
get 2 more chances to respond to this new
Okay.
issue.
So, so it's not a request for information. You have to be careful, right? Because what examiner does, he or she examines the claims, writes the reason why the claims are not patentable, what statutory requirements are not made. And then what you do is you go back and amend, and the claims are say that no, here are my arguments why they meet the requirements. Examiner will make it final, okay? Now, so there is no additional bites here. What you can do is that you can file what we call is a request for continued examination, RCE, and there is, filing fee for that, and then you can go further and go to another cycle. So that is the option. The other option are you can file you can let that abandon, and before it gets abandoned, you file a continuing application, and you may want to add new information in there if you think that will help, and it's called um, it's a type of continuing examination, but it's in part, right? Because you have added new subject matter to it. It's called CIP, continuation in part. So those are some other options you can, use to get further examination, or more
Thank
rounds
you.
of examination. I'm sorry.
That's okay. Thank you. We have just a few more questions. We'll keep responding until 2:15. Just want to give everyone a time check. So I'm going to go in through a few questions related to global patents and one last one on timing.
Mhm.
What is the timeline from filing a patent in the U.S. to the PCT application?
So I think it's within. So when you file the PCT application, that's I don't have the specific the time on that, but I think you have to check the PCT site. It's on our website as well as on the WIPO site when you can get the timeline on that. But there are requirements that I believe it is 30 months, but I don't want to give you wrong information.
Thank you. Since there is no worldwide patent, is there any advantage to file your technology as a trade secret? And does that keep your invention or innovation hidden?
Right. So it's all you, right? If you can hide your invention, I mean, Coca-Cola, that the formula has been, I guess, has been a trade secret for how many years? Hundreds of years. If you can do it, yes. I mean, people have tried to reverse engineer it, and still have not been able to copy it. So the trade secret, I think that's where the challenge is. If you can keep it secret, then you can, if not, then I think with patent at least you will have control, and you can, you can go after those who try to copy it, make it, and then you can, if the product is going to be so good and make so much money for you, then you may want to go to multiple markets, multiple countries, and protect there.
Thank you. When filing a patent in a foreign country, does the researcher need to translate and incorporate the provisional patent or only the permanent patent application?
I didn't understand. I mean, I think so again, if you're going by PCT route, then once you file a PCT application, your application gets fixed. Okay. Now you could file first a provisional and then file a PCT, and you can get benefit that way. People use multiple provisional applications. So if you are filing through PCT, you have a fixed application. If you are filing in each country, independently without going through PCT, then I guess it will depend on what you want to file there and what is your filing date.
Thank you. A simple question. If you have a challenge with your examiner, is it possible to request another examiner? And what's the process for that?
Good question. I don't think you can get a change of examiner, but there are ways to resolve it. First thing would be to talk to the supervisor of the examiner, and the Ombudsman program is there. If it doesn't work out with the supervisor, you can reach out to the director of that technology center. They will mediate. So there are several, options available. Like I said, Ombudsman program, you can reach out to them. And so they all will be available to help.
Thank you. And this is the last question from a person who has a 20-year patent, but the formulation of a previously unapproved by FDA medication is being marketed illegally by generic manufacturers. If I get approved by FDA as a new chemical entity, does my 20-year patent override any market exclusivity that the FDA will issue?
I'm not really sure I am equipped to answer that question. I mean, I'm a patent examiner, really. So sorry, I don't have the answer to that question.
Thank you. And we will chat out the resource link and include some of these links in our follow-up note to all of the registrants on this webinar so that you can dig a bit deeper and know where to get more information. With that said, I want to thank you, Dr. Shukla, for all of the information you've provided here today, as well as the resources. I'd also like to thank Lily Portilla of NCATS, as well as everyone who listened in for this webinar. We appreciate your time. We also appreciate your feedback. We've sent you a link to a feedback form if you would take a few minutes to fill it out. And if you have any additional questions or to schedule a one-on-one with Lily about the NCATS SBIR program, please reach out to us. Thank you very much for your time and have a wonderful day.
Thank you.
Thank you. Thank you.